Hi everyone, Samantha Fitzgerald here with SJF Law Group. Do you really need an attorney to do a probate administration in Florida? This is the time of DIY. Who wants to spend all that money on an attorney, right? Well, first of all, you're actually required by law to have an attorney in Florida. So there's two different types of probate administrations. There's something called a summary administration and a formal administration. A summary administration you are allowed to do on your own. No requirement to have a lawyer. There is no executor or personal representative appointed in that type of estate. Somebody is the petitioner, and only a beneficiary can be a petitioner. So I'm not really sure of the statistics, but probably about half of those cases end up being done without an attorney. But it's quite a complicated process depending on the nature of the assets, and it's certainly a lot faster and done properly when you have an attorney. But we're going to talk about formal administrations today, which is what I call a full-blown probate administration, the type that you are accustomed to knowing about. And as I said, you are actually required by law to have an attorney, unless there's one beneficiary. If the personal representative is the sole beneficiary, you're not required. But why would you want to have an attorney? Even if you weren't required by law to have an attorney, why would you want to have an attorney? Well, this is a very complicated process. This is a court case. It's a legal process. It's like saying I'm going to perform my own brain surgery on myself. Of course, you would never do that. You're going to need to know how to prepare legal documents such as deeds to real estate. You need to provide an accounting to the beneficiaries. You need to file tax returns. You need to notify creditors and publish notice in the newspaper. You need to make proper distributions to beneficiaries. And if you don't do some of these things properly, you, as the personal representative, can be personally responsible. You are a fiduciary appointed by the court, so you could be personally responsible to the Internal Revenue Service if you don't file tax returns and make sure the taxes were actually paid. That goes for even past taxes that the decedent might have owed. If you make distributions to beneficiaries and you don't properly pay creditors that should have been paid, you can be personally responsible to those creditors. Something as simple as, oh, I would like to buy the property from the estate and I'm going to get an appraisal and I'm going to pay fair market value for that property from the estate. Well, guess what? You've just breached your fiduciary duties because you are in an automatic position of a conflict unless you get permission from the court or the beneficiaries. So there are so many traps that you can fall into that are really big and disastrous for yourself potentially. You can get sued by the beneficiaries for your breach of your fiduciary responsibilities. And then who's going to pay your legal fees? There are a lot of rules surrounding that. So it's not a position that you want to be in. You want to do things properly. So not only are you required by law to have an attorney, but it's certainly a good idea because it is a very complicated process. And not only is the attorney going to help you do it properly, but the attorney is going to help you get to the finish line much, much faster than if you were doing it on your own. So thanks for watching our video. We have lots of other great videos on our YouTube channel, lots of probate videos. So if you have any questions about the probate process, please check out our other videos. And I'd love to hear your comments about probate. So please comment below if you've ever served as a personal representative or if you've been a beneficiary in an estate. Please comment below. Thanks.